is to win your client's cases despite the most impossible odds. This message will self-destruct in 5, 4, 3, 2.
Hi, my name is Dan Callahan, and I'm here to discuss what happens if you enter into a contract subject to misrepresentations or relying upon false statements of fact. So a frequent issue that comes up is what happens when you've entered the contract and you believe the other side either falsely represented facts or failed to disclose material significant facts that led you to enter into the contract. So first, let's sketch out the problem. This problem usually involves some false information or the concealment of true information by the other side, which leads you to enter the contract with them. You don't find out that the information is false until after you've entered the contract and suffered some harm. One classic case is if you agree to purchase a restaurant business, for example, for another party. The seller claims he's doing $500,000 worth of business every month, and that his net profit margin is 20% or $100,000 a month. Okay, you enter the contract, you're paying the money for the restaurant, you start running the restaurant with the same staff and recipes, and in the first 6 months, your revenues are only $50,000 a month. And not only is your net margin not 20% profit, you're losing money. This shows that even before entering the contract, the best way to protect yourself is doing your own diligence. Invest in an accountant to audit the financial statements provided by the seller. Is there something inconsistent about his books? People who doctor the books often overlook something. Hire a restaurant business consultant. Is it believable that this kind of restaurant has receipts of $500,000 a month? What's the usual performance of a restaurant in this market area that has 20 tables? The fees and expenses you'll spend to do this type of diligence are nothing in comparison to what you'll pay in lost profits and hiring an attorney. Now, similarly, if there are underlying promises that you're relying on in buying, say, a manufacturing business, put those promises in the contract. For instance, if you're relying on the promise that the business has favorable contracts with its suppliers for the last 5 years, put that promise in your purchase agreement for the business. In addition, all financial information provided by the seller should be referred to in the contract as being incorporated into the contract by reference and upon which you as a buyer are relying. Now, you should also confirm in the written agreement whether or not there are any potential claims against the business that would not be revealed through a diligent investigation. For example, if you later learn about an undisclosed sexual harassment claim against the business and that the claimant is seeking $1 million in damages, that lack of disclosure would give you grounds to sue the seller. After you discover that the formation of the contract was based upon a fraudulent representation, you can sue the seller. But what do you seek? What relief do you seek? Your suit can either seek rescission of the contract or damages. Rescission returns you to wherever you were prior to entering the contract. Alternatively, you can seek damages. That's the value of the loss occasioned by the misrepresentation. Okay? If you're suing for money damages, you have to prove how much you're harmed and how the seller's false statements actually caused you that harm. For instance, conceptually, if you paid $5 million for a business, based upon representations, it would have annual revenue of $10 million with 20% profit, or $2 million. And the actual performance of the business resulted in only $5 million in revenue and only $1 million in profit. Your damages for the first year alone would be $1 million. On top of that, if you can prove that the material misrepresentation or omission was intentional by the seller, you may be entitled to an award of punitive damages. Punitive damages is money above and beyond what it takes to make you whole. These damages are meant to punish the wrongdoer and can be 3 or 4 times the amount of your provable loss. Finally, if the purchase and sale contract between you and the seller has an attorney's fees clause, a provision that allows the winning side to recover his or her attorney's fees against the losing party, you may be entitled to recover all of your attorney's fees incurred in bringing the lawsuit. However, if your contract does not contain such a provision, neither party, regardless who wins, will be entitled to recover their attorney's fees. In my career, I've handled literally hundreds of cases that involve allegations of fraud involved in the formation or performance of contracts. So I'd be willing to review your case and advise you whether or not your case has any elements of fraud and how that could potentially impact the handling and resolution of your case. For more information, visit my website, callahanconsulting.com. Thank you.